Thank you for joining us today on our webcast on living and working with adjudication. As you can tell, this webcast is about the new adjudication provisions of the Construction Act, and that came into force on October 1st, 2019. My name is Andrew Salvador, and I'm here with Brendan Bowles, a partner at Glaholt LLP. Today, Brendan and I will be speaking about the transition into adjudication and what that means for your business. Duncan Glaholt and Jacob McClellan will follow by discussing the overlap of adjudication with contractual dispute resolution processes. Lena Wang and Ivan Merrow will be discussing multi-party and competing adjudications. And finally, Michael Vallow and Pavle Levkovic will be discussing the process of enforcing or challenging a decision of an adjudicator. Now, on your screen right now, you should be able to see a text box where you can ask questions throughout the discussion and our presentation today. We encourage you to ask questions. They'll be provided to us in live time, and we'll do our best to answer the questions during our segment or before the segment ends. There's a lot of content to go through today, so to get things started, Brendan, it's past October 1st, 2019. Adjudication provisions are now in full force. If I'm a contractor and I have a live project right now, do I have to be concerned about the adjudication provisions? When do they apply to me?
Yeah, and I think the best answer I can give, Andrew, and thank you, is that it depends on whether or not by live you mean you're at the point where you're doing work, shovels are in the ground, or whether it's a matter where the matter is just about to go out for bid and we're thinking about a contract that we're about to negotiate and the terms that we want to think about and how adjudication might apply. As Andrew said, October 1st is the key date, and the transition to adjudication is gradual. So the short answer is it's very unlikely that if you have something come across your desk this afternoon on a project that's underway where payment isn't flowing and people are in a dispute, that you'll be subject to these adjudication provisions. Because the transition is gradual, what we're going to be talking about are more matters for the future. But the future is coming quickly because October 1st is the key date as set out in the slide. And so, for example, if the matter is about to go out for bid now, and we're going to be entering into a contract negotiation, and you're asked this afternoon to think about these things, we're going to start to see adjudication apply to live construction projects as we go forward. Now, for those of you who've maybe heard some of these seminars before and maybe read a bit about it, you'll recall that when the Act first came in, July 1, 2018, there was a transition then based on those modernization provisions, for example, extending the time to register a lien, that was based on when a contract was entered into or when it was procured. This works the same way. October 1 being the key date, and the contract as between contractor and owner, as those terms are defined by the Act, being the key concept in order to determine whether or not it applies to us. So, for example, if you're a subcontractor, you look at that contract, that prime contract, if you will, to determine whether or not adjudication applies, and you consider the date. Now, date entered into, I think, is pretty understandable. Even if you look at it from a layperson's perspective, when did the contract get signed, for example? Procurement is defined, thankfully, by the Act. So there's 4 examples of it. One is a request for qualifications. One is a request for quotation, request for proposals, and finally a call for tenders. So there's a document that you can look at. And if it was issued on or after October 1, 2019, these provisions now apply. So, Andrew, I was mentioning earlier, if you get something across your desk this afternoon and it's a new contract, this might be something that you want to think about. What if we have dispute resolution provisions we've used in our contracts before? We're familiar with them, we're comfortable with them, DREs, arbitration, you name it.
Right.
How do you deal with this new adjudication regime and when we have those systems that we're used to?
Right. So, yeah, that's a common question that we're getting from clients now. They know the new adjudication provisions are in effect. They come to us saying that we are comfortable with our dispute resolution provisions in our standard go-to contracts. Perhaps I would say that disputes under $100,000 are to go to mediation. We're comfortable with that. We used it in the past. and we do not want to use the new adjudication provisions because we know that this other process that we're used to works. So the wording of the Act actually helps alleviate some concerns here. If you look at the wording of the Act, or Section 13.5 of the Act, it says a party to a contract may refer to adjudication a dispute with the other party to the contract respecting, and then it goes on to list a number of enumerated items for which adjudication applies. The Act is permissive in the sense that it states that the party to a contract may refer the dispute to adjudication. If the contractor, it doesn't, depending on what the contract states, if you're used to a mediation process, one of the parties to the contract can unilaterally use Section 13.5 of the Act and bind adjudication on the other party. Now, the reason why I say that is, and notwithstanding what the contract already states, Section 5 of the Act states that the contract or subcontract you've entered into is deemed to be amended insofar as necessary to be in conformity with the Act. What that means is if you have a party that unilaterally decides to use adjudication rather than the contractual dispute resolution provisions, then they are allowed to use the adjudication, and the Act is deemed to be amended, or the contract is deemed to be amended insofar as necessary to be in conformance with the Act. So in terms of actually getting started on this process, ODAC, which is the body that was set up to, the organization that is set up to allow for this new adjudication process. So ODAC stands for Ontario Dispute Adjudication for Construction Contracts. It created a system that allows you to actually get started and initiate your adjudication. The notice of adjudication on ODAC's website requires a contractor or a party to the contract to log in, create a new account, and to identify if they're a representative to the party or an actual party to the contract, and submit their notice of adjudication. Once the notice of adjudication has been fully set up, the contractor or the representative will then have to select an adjudicator from a roster. If the parties agree to an adjudicator, then that adjudicator will get a notification letting them know that they have been selected, and they can either consent to he or she can consent to the election, or they can decline, in which case they will have to find a new adjudicator. If the parties do not agree to an adjudicator, then the process will ODAC can get involved and select an adjudicator for the parties. So once an adjudicator is selected and the adjudicator accepts their appointment, then the adjudicator will work with the parties to determine which process will work best for their particular dispute. Now, when we went on the ODAC's website, they have 5 pre-designed processes set up. And Brennan, with your experience in the construction litigation industry, what are your thoughts on the 5 pre-designed processes that ODAC had set out in their website?
Well, in terms of the construction litigation industry, I think this is going to be a very exciting alternative for people, because I think it truly will be faster and less expensive. However, it's going to be binding on an interim basis, which is key as I go through my remarks to keep in mind as to what these processes will actually look like. Now, Andrew, I think that was very helpful to go through the website, because that's where people should start. That's where they should go, the ODAC website, to get signed up, get a username. That's how this works. Like anything else in life now, you get a username and you sign up for something online. The adjudication doesn't actually happen online, of course, but it happens in a very summary fashion. These 5 different pre-designed processes that the ODAC has set out are all, for the most part, very summary, very binding, and heavily dependent on written documents, as you can see. The spectrum goes from very simple, just two pages long, less than $1,000, $800 for the adjudicator fee, to a more open-ended process to be determined by the adjudicator. Ultimately, under the Act, all these processes are subject to the adjudicator making a a decision as to how the process is going to look. But there's certain goals that ODAC has, which I think are reflected in these processes. One is to give people cost certainty. Another is to give the parties the ability to have input into their process along with the adjudicator. And very important, obviously, is proportionality. Is the process going to be proportionate to what's actually at issue? So keep in mind that all of these processes, all 5, are intended to take place in 35 days, subject to certain exceptions. And all of them are binding on an interim basis. So the reason I emphasize that is that even a more complicated matter, where you may wish to retain an adjudicator who is going to be charging you more than what these pre-prescribed rates are for a more extensive process, because the matter is more complex. There's higher amounts in dispute, and it's proportionate to have a process like that. The default is going to be 35 days unless the parties agree to a longer time period and the adjudicator consents to that. Now, the adjudicator, if the adjudicator feels they need more time and the parties aren't asking for it, the adjudicator can ask for an additional 14 days and the parties can consent to that. But as you can see, these are very narrow windows still. You cannot, I think, realistically have a full-blown arbitration-like process within that context. Now, in addition to that, let's say the parties say, well, wait a minute, maybe we could use this adjudication more like an arbitration. Maybe we can have exchange of documents, maybe even some discoveries, probably not. But we want an oral hearing, we want cross-examination, we want something more adversarial, something more traditional. Remember, they're going to have to agree to that. The adjudicator is going to have to consent to that. You're going to have a whole lot of people who, to put it in plain English, are fighting over money, and someone who wants to get paid, probably quickly, agreeing to dispense with the benefit of this interim binding process. And to spend that sort of resource only to find that the decision is binding only on an interim basis, not a final basis. So I don't think, and it's just a personal opinion, that you're going to see option 5, for example, oust arbitration from the scene in Ontario. However, the main takeaways here are there are options for parties who want to adjudicate that can allow for different sizes of dispute to be done in this very summary fashion.
That's right.
And so, Andrew, we're on a timeline here to get finished quickly.
Yeah.
And people on an adjudication are on a timeline to do it quickly. Do you have some quick takeaways just to end our session?
That's
what
right.
people can do in order to try to manage these timelines.
That's right. And I know some of the questions start to come through. What we're going to do is we're going to answer those questions via email after this session. But in terms of some quick tips for parties that are in are concerned about adjudication. Very first and foremost, before you even get into whether this process of adjudication does adjudication apply to you, maybe specify in your contract if the adjudication procedure is going to apply to your situation. So that means if a procurement process started before October 1st, specify in your contract, add certainty so the parties know where they stand. They know if adjudication applies. Familiarize your team with the new standard form contracts that are available on Ontario Court Form's website. Prompt payment and adjudication go hand in hand. There's standard form standard forms on the Ontario Court's website that you want to be accustomed to. You want to know how they work. You want to know which ones apply to your situation and be able to get those out quickly. Be organized and ready to provide relevant documents to an adjudicator quickly. The key to success with these tight timelines is to make sure that we have the ability to get an adjudicator the information they require quickly. That requires a lot of organization. When you're working with these tight timelines, you do not want to appear disorganized. You're not going to get the result that you want out of the adjudication, if that's the case. And lastly, just have a system in place to track key dates. Know when invoices are due. After you get a proper invoice, know when you have to pay your subcontractors if you're a contractor. Know which notice of non-payment applies to you. Know about the deadlines in adjudication, and have someone in your organization ready and willing to act on these tight deadlines. And lastly, you don't want to lose sight of your lien rights. In that respect, Brendan, we were discussing earlier your experience on how the Act worked for the majority of your career, and now how this new provision in the Act with respect vis-a-vis the lien rights applies.
Yes, and I'll just say in one sentence, you can now extend your lien rights by 45 days if you're in an adjudication, but use with extreme caution because it's brand new and we don't really know exactly how that's going to work out, but it's probably worth another webinar at some point.
That's right.
Thank you.
Thank you very
And
much.
so we're going to now turn it over to our colleagues Duncan Glaholt and Jacob McClelland. We're going to talk about overlap of different processes with adjudication.
Thank you.
Hello, my name is Jacob McClellan. I'm an associate here at Glaholt LLP, and I'm joined by Duncan Glaholt.
Good morning, everybody.
We're going to be talking about the overlap of adjudication with other contractual dispute resolution processes.
Correct.
In doing so, we're going to try and answer 4 particular questions for the audience. First, how does adjudication work where a contract has a mandatory arbitration or mediation clause? Second, what are some of the practical implications if there is a dispute resolution board in place for a project? Third, if the parties to an adjudication have a confidentiality clause in the contract between them, will the results of the adjudication be made public? And fourth, can the successful party to an adjudication use the decision as evidence in a contractually ordered dispute resolution process?
Thank you, Jacob. Do you mind if I speak up for the first 2? They're the easy ones. I'll leave the hard ones for you.
Please do.
All right, good. So I'll deal with the first 2 of these questions, but first, because I have the microphone, I'm going to just touch on 2 things that Brendan and Andrew mentioned earlier. Managing dates. I would say to the group on the webinar that there are some very useful software programs that have been developed to help you manage dates, so please, those of you listening, look to those. Second, Jacob, if I could, the processes, the 5 sort of pre-potted processes that you'll see from ODAC, please think of those as managing the expectations of the user group. So you know if you choose the process at a certain price point, you have some sense of what you're getting for the money you're paying. But I promised I'd speak about these topics, Jacob, so I'll do that. So how does adjudication work where a contract has a mandatory arbitration or mediation clause? That was touched on very briefly by Andrew. The key point to the audience is, the key takeaway is this: statutory adjudication only adds to the remedies you've got and the processes available. It takes nothing away. So as Andrew correctly said, your ability to mediate, your ability to arbitrate, those processes that you're familiar with are unaffected in many ways. I would draw your attention to the slide that we have here, section 13.5, subsection 5, which you can certainly read for yourselves. It expressly provides that if you have a matter for court action or arbitration, it's unaffected by adjudication unless the arbitration or action has been finally determined. So post-judgment, post-award, you cannot access adjudication, but prior to that, you have both remedies. Mediation I find very interesting. You know, all of you, that I'm a strong proponent of mediation at all times, often, and at all points before, during, and after an adjudication, you can mediate. And if you just look at 13.15 subsection 1, you'll see the provision for that right in the statute. So the determination, in short, you'll read this as I'm talking, of a matter by an adjudicator is binding until a determination by court, by an arbitrator, or look at the last phrase, please, or a written agreement between the parties respecting the matter. So it remains open to anyone who prefers mediation to mediate before, during, or after a mediation. Even in the face of an adjudicator's determination, I think you could still mediate in a serious case. That's my view, at least. It'll be interesting to see how this develops. And you can't keep me away from the microphone once you get me started, Jacob. So I'm just going to run, if I can, right into the second question here. And this I found fascinating. We're going to have to find our way, all of us, through this procedure. But the question raises some very interesting issues. What if there is a dispute resolution board, or a DRB, in place for a project? These DRBs can be standing DRBs, where 3 experts are impaneled at the beginning of a project, Jacob, and they go to occasional quarterly often meetings and they keep up with a project, or they can be ad hoc, they can be sent up to fulfill their purpose. But here's a distinction for the audience listening. DRBs, in essence, give recommendations. They do not give binding determinations. They are very, very useful in giving recommendations, subsurface soil conditions, technical questions, welding questions, pipeline construction, water main construction. DRBs can be very, very successful on large projects. There's nothing about adjudication, I think, that's inconsistent with that. Adjudication here is hand in glove with prompt payment. So I can see a standing DRB on a project functioning perfectly with adjudication over individual payment disputes. What I would say, to be provocative for the audience today, is I can see a role for a certified adjudicator, a roster adjudicator, to be part of, perhaps chair of, a standing DRB. So when a recommendation is made by the DRB, the process isn't lost. The parties get the advantage of the benefit of the DRB, but if the parties will not accept the recommendation, all the work's being done to deliver an adjudication over a related payment dispute. So, like so much of the statute, to the audience, you lose nothing, you gain a process.
Thank you, Duncan. I think that was some great insight, and I'm sure our audience will appreciate that. We'll move on to our third question, and that is, if the parties to an adjudication have a confidentiality clause in the contract between them, will the results of the adjudication be made public? The first thing to note is that an adjudicator has a duty of confidentiality, in that he or she shall not at any time disclose or release by any means confidential information, except as required by law. That being said, while an adjudicator is bound by the duty to maintain confidentiality, there is nothing in the Act that imposes this duty on the parties themselves. There is also no equivalent to the deemed undertaking rule under the Construction Act, which means that a confidentiality clause will indeed be necessary in order to ensure that the parties maintain confidentiality leading up to and during an adjudication.
Just before you go on with that, Jacob, let me just make a point about adjudicators. When you look at the powers of adjudicators, they're going to be exercising inquisitorial power. They're going to be finding out things that are themselves confidential. And I don't want to take away from your time, but I think a note to the adjudicators out there, or people that will become adjudicators, you're going to have to be so careful to use good judgment as to what you put in your determination, because that determination could, as you'll undoubtedly suggest, become a court document.
Right.
So, and I think counsel advising clients in determinations have to be careful a little bit what they put in, because it could find its way into a determination.
Right. That's a perfect precursor, Duncan. So the question remains, can a confidentiality clause prevent the results of an adjudication from becoming public? And our suggestion is probably not. Under subsection 1320, sub 1 of the Act, a party to an adjudication may file a certified copy of the determination of an adjudicator with the court. And on filing, the determination is enforceable as if it was an order of the court. What's more is that the Courts of Justice Act, as we all know, provides that on payment of a prescribed fee, a person is entitled to see any document filed in a civil proceeding, unless an act or an order of the court provides otherwise. So given that the Act is silent on this particular issue, the only thing that can really prevent an adjudicator's determination from becoming public is a sealing order, which I would submit, Duncan, is unlikely to be granted in these circumstances.
I think you could take that to the bank, Jacob. I don't think a sealing order would be granted by a court. In the context of this legislation, I think that would be a non-starter.
So what does this mean in practical terms? First of all, if the parties to a construction contract want to keep their dispute private, then they should agree to a confidentiality clause.
Agreed.
However, beyond that, if the non-successful party does not want the results of the adjudication to become public, then they will need to pay. Otherwise, the successful party will be free to file that determination with the court and commence enforcement proceedings.
There's a question that's been asked, but I think what we'll do is, Jacob, go ahead with the second question. This question relates more to the last question that you're addressing.
Sure.
Okay. If we have time.
So our fourth and final question that we'd like to answer for our audience is, can a successful party in an adjudication use an adjudicator's decision as evidence in a contractually ordered dispute resolution process? And the answer to this is yes. The Act contemplates that an adjudicator's decision is only interim, and that means, while binding on the parties, subsection 13.15, subsection 1 of the Act provides that the decision is subject to a final determination of the matter at issue by a court, an arbitrator, or, as you mentioned, Duncan, a written agreement between the parties respecting the matter. In addition, subsection 13.15 sub 2 provides that nothing in the Act restricts the authority of the court or an arbitrator to consider the merits of the matter determined by the adjudicator. It remains to be seen, however, whether judicial guidelines will be developed in terms of the weight afforded to these decisions. I would submit, though, Duncan, and perhaps you may disagree with me, that these decisions are likely to be of little probative value given the restrictive processes contemplated by the Act.
Yeah, look, Jacob, I would agree with that. And I think that's been the experience in other jurisdictions. You can imagine that if you were a judge on a full record, looking at a determination done in 35 days on a partial record, made by a person who may not be legally trained, made by a person who is entitled to pay attention to hearsay, you might not give that a lot of weight. So I think by and large, the rule will be that they'll be given little weight in subsequent proceedings. You have to understand, though, Jacob, and this is an important point that needs to be emphasized. Look, please, the audience should look at the powers granted to an adjudicator to get their job done. I've argued elsewhere that those powers in some respects could be turned into duties. Three of them that come to mind are taking the initiative to inquire into the law and facts. Think of the confidentiality issues that could arise there. Think of the ways that one could go astray. Drawing inferences based on the conduct of the parties. That's another power an adjudicator can exercise. And conducting on-site inspections. So I think courts will be very reluctant to give too much weight to adjudications. Now, the exception may be where parties are disputing a highly technical subject, such as how much or how many cubic yards of earth were moved. And if there's evidence from quantity surveyors, there may be some cases where a judge might say, well, they've done the work for me to add up the totals or to sum up interest calculations, for example, so I'm going to pay attention to that. But it won't be binding. In some cases, it won't even be interesting, but it will always be evidence.
Right. The only thing that I would add is that the Act also provides that an adjudicator shall not be compelled to give evidence in any action or other proceeding in respect of a matter that was the subject of an adjudication. So it's only the determination that's going to be entered into evidence. The adjudicator can't be called as a witness. He isn't going to be able to provide additional reasons for that determination. It's only going to be the determination that's going to be allowed to be entered into evidence.
Thank you, Jacob. And I would say to the group listening to the broadcast here that if you were thinking of becoming an adjudicator, bear that in mind. What you've said is extremely important. Your determination will speak for you. Once you sign that determination and it issues out into the world, it could be registered as a public document. If it goes to the divisional court, you won't be there to explain to the justices looking at it what you meant by paragraph 8 or 9. We're all of us are going to have to get very good at writing very good determinations that speak for us, because that will be a document that will be permanent.
Right. And just off of one of the questions that we did see come in, we have a little bit of time left here. It's our understanding that there won't be a database of adjudication decisions. You won't be able to get onto Canley or Westlaw or Quick Law and find these decisions.
Right.
Maybe that's something that will come up in the future, but as far as we know, there won't be a central database for these decisions.
Yes, that's right. And that means, in answer to the specific question that one of our audience asked, they will have no precedential value. But I think the person that asked the question was asking a slightly different question. They weren't asking the lawyer's question, which is this determination binding on some other adjudicator in some other case. I think what this person is asking is, if you have an adjudicator decide 3 sequential adjudications on a project, is that adjudicator bound by her rulings on the first 2 adjudications? So if she has said on the first one that the contract provides that this item is not an extra, and the next payment application and the one after that involve the same issue, is she bound to follow her own reasoning in that first determination? And would it be wrong to come to a different conclusion? Could they overturn an earlier adjudication on the basis of subsequent reasoning? I think it's a very subtle question that was asked here, and I have no good answer for it. But I think if it's a reasoned decision, those reasons should be fairly consistent across a number of adjudications.
Right. Well, it's certainly an exciting time for the construction industry. It's an exciting time for us. That concludes our discussion on the subject of overlap of adjudication with other contractual dispute resolution processes.
We're getting good at this. We should do this again.
That's right, Duncan. We'll invite our next presenters, Lena Wang and Ivan Merrill, to discuss the topic of enforcing or challenging an adjudicator's decision. Thank you
very much.
Hi, my name is Ivan Merrill. I'm an associate lawyer at Glaholt LLP. I'd like to introduce my colleague, Lena Wang, also an associate here at Glaholt LLP. We just want to thank Duncan and Jacob for surveying a few different ways that adjudications can interact with other contractual dispute resolution mechanisms. Now, assuming that adjudication has been chosen as an option to resolve a dispute on your project, and that the deadlines discussed even earlier by Andrew and Brendan apply, so we're in adjudication, Lena. Can you describe to us a few of the issues that we see coming down the line where we might want to have multiple parties join into to an adjudication? But before we get to that multi-party issue, let's really break it down and just talk about who can start an adjudication.
Sure. So I'm just going to switch to the next slide. So the Act provides that a party to a contract may refer to adjudication a dispute with the other party to a contract. And similarly, that applies to a party to a subcontract, referring to adjudication a dispute with the other party to that subcontract. So what that means is, based on the language of the Act, that parties working on the same improvement but not in contract with each other are not automatically in the same adjudication. However, Ivan, we all know that construction disputes arise and often involve multiple parties, sometimes on different levels of the construction pyramid. Is there any way to add a third party, say, to an already existing adjudication?
Well, that's a great question, Lena. Luckily, I'm prepared to answer it. So on many construction projects, it's not just often as simple as a contractor subcontractor issue that may be able to be resolved just through a two-party adjudication. So we've already started looking at the Act and trying to find ways to join in multiple parties. Now, in traditional litigation, you have a lot of options. One of the most popular options, when you're facing a claim from somebody and you see a third party as liable, you have the option to commence a third-party claim against that individual organization to pin liability properly on that other individual who you believe is responsible for the claim against you. In adjudication, we haven't found a mechanism quite like that to add a third party into what we call a two-party adjudication. You can't commence a third-party adjudication to bring them into yours. Instead, what we're looking at are the mechanisms available in the Act that allow you to consolidate. Now, what we mean by consolidation is that two different adjudications need to have already been commenced. The other rules that we talked about earlier in the webcast today apply. So a proper party to an adjudication has to be party to a contract. And once two different adjudications have been commenced by parties to a contract, the Act provides for consolidation. Now, contractors are unique in that they have the ability to require that adjudications be consolidated under the new Act. But that's unique to contractors. And what I mean by contractors is, as they're defined under the Act, a contractor is an individual with a contract directly with the owner of the premises undergoing the improvement. Now, if you're not a contractor, this is an issue because as an owner or a subcontractor, you don't have that power granted by the Act to require these two different adjudications to be consolidated together. There's only the option to request that two different adjudications be consolidated, but it remains subject to the parties' agreement. And you can imagine a scenario where parties are not being cooperative and may refuse a consolidation. And that may cause an issue if you haven't provided for that already in your contract. Now, what I'm getting at is that the Act isn't just limited to the adjudication procedures set out in the legislation. There's a subsection that allows you to add in adjudication provisions as part of your contractual agreement between parties. So we see this as a potential avenue to cover this gap. And perhaps in the contract, you may require a contractor in certain cases to require that multiple adjudications be consolidated. So flag this issue for follow-up with us if you're an owner or a subcontractor and you're concerned about this consolidation issue. We also see the potential for an adjudicator to get involved in this consolidation issue. Although we see a few gaps such that adjudicators may not be able to go so far as to order consolidation to take place, we do just want to highlight two potential provisions that we found in the powers of an adjudicator that may allow them to tie in other parties and force them to participate in the process. Adjudicators under Section 13.12 of the Act do have the power to obtain the assistance of another individual. Now, we might more naturally think of this as obtaining the assistance of an expert, where the adjudicator can make a request and require that an expert participate. But if a third party exists out there and there's no adjudication against that individual organization, so consolidation isn't an option, the adjudicator may require that they participate in order to assist in building the facts. So you can see a potential scenario where an adjudicator may be encouraged to exercise their powers to have that party participate, at least as from a factual or documentation standpoint, although they won't be a party under the Act and therefore may not be subject to the adjudicator's order at the end of the adjudication. Now, I've just flagged a few different issues, Lena. Perhaps we can switch gears and talk about a scenario that Duncan alluded to earlier, which is the case of competing adjudications. So when there are multiple adjudication orders in the span of a project and they may not all align perfectly, or perhaps there's different adjudications going on in the same project, different adjudicators entirely, and they're making decisions that might conflict.
Certainly. So what I was alluding to is what we're calling conflicting determinations. Because the Act provides for consolidation of separate adjudications, there should not be, that's a way to reduce the possibility of conflicting determinations. But we have identified a few scenarios where there could be conflicting determinations. The first one, which is on the slide as example one, is regarding when you give notice of consolidation too late. So just to back up a few steps, there's always the possibility of conflicting determinations from parallel proceedings, parallel adjudications, if the contractor is not interested in consolidation. So as Ivan alluded to, the contractor can require other parties in separate adjudication proceedings to consolidate. Now, if the contractor doesn't want to do that, then there's always the possibility of parallel proceedings that could result in conflicting determinations. If the contractor is interested in consolidating separate adjudications, the regulations right now provide that a contractor has to give a notice of consolidation no later than 5 days after the transmission of documents that the parties want to rely on to the adjudicator. So that means, so what happens if the contractor gives a late notice of consolidation? So for example, if I give a notice not on the 5th day, but on the 6th day, the Act doesn't provide for what happens. And you can see there's a possibility that if the two separate adjudications continue to proceed in parallel, then there could be conflicting determinations. Now, parties can still agree in that scenario to consolidate those proceedings because there is no deadline in the Act or the regulations for when you need to give a notice of consolidation if the parties agree to a consolidation. that deadline applies only if the contractor is requiring parties that would not otherwise agree to consolidate those proceedings. So there is still a possibility that the parties in that scenario can agree to consolidate and avoid the possibility of competing determinations, but it is certainly a possibility. The second example is what Duncan alluded to, and we're calling it serial adjudications. And that's if not so much parallel proceedings, but separate adjudications, perhaps conducted by the same person, perhaps not, over similar or related issues. So imagine an owner and a contractor can't agree on how to value a change. It's additional work, but the owner directs the contractor to proceed regardless. When it comes time to invoice for that work, the contractor invoices for the amount that he or she thinks is due, and the owner makes partial payment and gives a notice of non-payment for the disputed portion. The parties go into adjudication, select an adjudicator, and the adjudicator gives a determination for that specific change, the value of that specific change. And in doing so, he or she specifies the method that he or she relied on to come up with the value of that change. Now, a few months later, a similar issue could arise, and it could be, it's with respect to a different change and maybe a different discipline of work. And the parties go through the same process. Perhaps they have a different adjudicator. I think this applies mostly if they have a different adjudicator. For whatever reason, the first adjudicator is not selected or appointed, and the parties use a second adjudicator. That adjudicator gives a determination that values the specific change, but relies on a different method in getting to that value. So now, in that scenario, that could be two conflicting determinations by two different adjudicators on the same project. What happens in that scenario, as Duncan said, perhaps the parties need to go to the court or to an arbitrator to resolve that if they can't come to a resolution themselves. But it is certainly one of the scenarios we've identified as being possible that leads to a conflicting determination. Now, Ivan, knowing that there's the possibility of conflicting determinations, is there any way that parties can avoid competing adjudications?
Yes, there is, Lena. I want to just review a couple of the best practices raised by Brennan and Andrew earlier. They apply absolutely to this situation as well. You want to be organized. You want to think about these issues proactively in advance, know which regime you're in and whether or not a particular project is going to be subject to adjudication. If it is, we need to look at the contract and think ahead to what are the obligations of the different parties to exchange some of this key information. Do parties have an obligation to give you notice if they're commencing an adjudication further on down the chain of your project? Let's be proactive and build in mechanisms in your contract using that provision that allows us to add additional adjudication procedures to make sure that you're informed and you have the information that you need to be able to assess whether or not a consolidation might be available or appropriate, or whether there's a way to download a prime contract at the highest level of the construction supply chain into all the further subcontracts, so everybody is subject to the same rules, and we're not operating under these different adjudications. Those are all important things to keep in mind: being proactive, being organized, making sure you know what regime you're in, and also acting quickly, because you mentioned that 5-day deadline to serve that notice of consolidation. That's important, and we don't want to have that question come up too many times of, I missed the notice to consolidate, 5-day deadline, what do I do next?
Certainly.
Yeah. All right, so now we'll be handing it over to two of our colleagues for the last topic in this webinar.
Hi there, I'm Michael Vallow, a partner here at Glaholt, and I'm here with my associate, Pavle Levkovic. And naturally, we're here to talk about what everyone's been waiting for, which is the enforcement and challenging of a adjudication decision. So let's jump right into it with the limited time we have left. Now, as everyone knows, adjudicators' decisions under the new regime are binding as soon as they're communicated to the parties. And And in fact, as Pavle will touch on shortly, any amounts due and owing coming out of a decision are payable within 10 days. And these decisions only cease to be binding upon the parties following the determination of the same issues, either by a court or by arbitrator or, of course, by agreement of the parties. So they're what we call interim binding. Now, to the extent the parties wish to have the issue re-litigated, so to speak, or finally decided, that decision's done by a judge or an arbitrator completely de novo, which means it's not an appeal, but the issue is reheard. And in fact, the decision of the adjudicator can be relied on as evidenced by the parties. Also worth noting, the decision of an adjudicator only ceases to be binding once a determination is made. So the mere fact that one of the parties has taken the step of referring the issue to litigation or arbitration doesn't act as a stay of the decision, and it certainly doesn't unwind it. That's only at the time a decision is actually issued by a judge or an arbitrator or a tribunal. And we'll come back to that in a moment. So looking forward, challenging and enforcing decisions are addressed under the Act at 1318, which deals with setting aside the decision of an adjudicator on judicial review. And enforcement by the court is the subject of 13.20, which Pavle is going to address. So first, let's talk about what setting aside an adjudicator's decision looks like under the Act. The first thing you'll note is that your right to have the decision of an adjudicator set aside on judicial review to the divisional court is subject to leave by that court. Now, one thing the Act happens to be silent on is what is required to be shown by a party seeking leave to bring an application to set aside the adjudicator's decision. The test that we're talking about here is actually not contained anywhere in the Act, and the rules of civil procedure aren't much help either. And so this is something we'll be watching closely at as these issues start making their way through our courts. Presumably on a leave motion, the party moving would have to show that there's some reasonable basis for making out one of the enumerated grounds to set aside the decision, but there's not much more we know about it at this point. The motion for leave, importantly, is time limited. If you're going to bring a motion for leave to set aside the adjudicator's decision, it's got to be done within 30 days. Which is interesting because the right of a party to bring a de novo hearing on the issue, either by way of arbitration or by litigation, is not subject to any timeline restriction. So taking the judicial review approach is limited by 30 days, but not the de novo approach. And that was a policy decision that was made by the drafters of the legislation. And so adjudication doesn't necessarily do away with disputes arising while the project is still ongoing. Importantly, motions for leave can be dismissed without reasons, and there is no appeal from the dismissal. Other things to keep in mind are that in the event the motion is successful, just because you're applying to have the adjudicator's decision set aside does not mean it's automatically stayed. The binding nature of that decision remains in full force and effect and would be payable within 10 days of its communication to the parties. That doesn't change unless the divisional court decides so. So that's important to keep in mind. So why don't we look then at what the actual enumerated grounds justifying setting aside an award are. And for anyone that practices arbitration, pardon me, for anyone that practices arbitration, these grounds are going to look very familiar. And in fact, they're very similar to the grounds for setting aside an arbitral award under the Model Law, for example, or the Arbitration Act. What you'll notice right away is that what we're talking about here on judicial review is not an appeal. This is very much something different. This is an application to have the decision set aside based on these 7 grounds. And what the divisional court is going to look at is not the merits of the decision or even the reasons behind the decision. What they're looking at primarily, as you can see from the enumerated grounds, is really the conduct of the arbitration, the conduct of the adjudication, making sure the process was fair, that the parties had an opportunity to be heard, that the adjudicator had the appropriate jurisdiction, that the adjudicator was not biased, and that the decision was not the result of fraud. So the review is not on a reasonableness standard or a correctness standard, so to speak, because it's actually not the reasons that are being evaluated. It's more the conduct and nature of the decision that was made. Now, turning then to the next slide, and just before I get there, one thing I want to note is, or I'll go back since it'll be a little bit easier. Have I done that here? Right. One of the options on judicial review to set it aside is in the event the decision of the adjudicator is in fact set aside, the divisional court has the right to have the successful party pay back monies that were paid in connection with the decision, some or all of them. And the idea that some but not all monies would be paid back is interesting because that would require that only part of the decision be set aside. But importantly, there's nothing in the Construction Act that permits for an award to be partially set aside in the same way that, for example, the Arbitration Act has, which expressly provides that awards can be severed, so to speak, and the impugned portion can be cut out. So it's not clear under the Act whether that was intended or not. Certainly, looking at the grounds for setting aside an adjudicator's decision, they don't lend themselves to severing a decision. I mean, to the extent a party was under a legal incapacity, that's not going to influence part of the award. It would influence all of it. Though number 3, arguably, to the extent multiple issues were determined by the adjudicator, if one of them were not properly the subject of the adjudication, perhaps it could be cut out by the divisional court and set aside, but certainly that ability is not expressly provided for under the under the Construction Act. And so that's currently up in the air and something we'll also be watching closely. So now, Pavle, I'll turn it over to you to speak about enforcing your decisions.
Great, thank you, Michael. So just before we segue into enforcement, we should touch on amounts payable. So what happens when there's a payment that's owing as a result of a determination? So Section 13.19 addresses this, and the bottom line is that payment is due no later than 10 days after the determination is communicated to the parties. Now, there's a couple of things that you might want to keep in mind. So first, interest. So interest does accrue on amounts not paid. But again, that's it starts running from the 10-day period after the determination is communicated. The important thing is that if an amount is not paid, work can be suspended until such payment is made. So this is the real lever of the enforcement provisions and this area of the Construction Act. So if you're not paid, the ability to suspend is something that you're going to see being exercised, probably quite a bit more to try to make sure that the interim binding nature of adjudication is really stuck to, that it's kind of a binding thing that happens. So if payment is not forthcoming, then the threat of suspension is going to be ever present. The other thing to keep in mind is that there's quite a bit of risk involved in not paying. So not only would you be liable for the reasonable costs of suspension, but if you don't pay, you would also be liable for the amounts that are due as a result of the resumption of work. So both the suspension and the resumption can also be included in that amount that you have to pay. So again, there's quite a bit of a risk here in not payment. And the final thing to keep in mind is that the amounts payable are subject to holdback. So when you do make payment, just make sure that you're retaining holdback as required by the Act. Now, moving into enforcement. So in Section 1320, we see that a party to an adjudication may file a certified copy of the determination with the court. And now, when they do that, it becomes as if it were an order of the court. So it goes from determination to an actual court order. The question, of course, becomes, how do you actually file? So do you just take your determination down to the courthouse and show up and say, I'd like to get this turned into an order? Well, it might not be that easy. So our law clerks here at Glaholt did get in touch with the court and with the master's office, but unfortunately, we're still waiting to hear back on how that mechanism would actually work. So one way that it could work, a possible solution, would be that you need a little bit more paperwork. So you might have to show up with something resembling a motion record, and then you'd have to have an affidavit, and the affidavit would attach the adjudicator's determination, and you'd use that to go before a master, say at ex parte motions court, and then have the master turn it into an order. The issue is that if you show up, there's no court file number yet because an adjudicator, is not a judge. So you haven't really commenced an action. So the end goal of having the determination turned into a court order just needs a few additional administrative steps, and those I'm sure will be worked out, and we will hear about them sooner rather than later. So the other issue is the deadline. So once you file your determination, what's the deadline to actually file your determination? And the baseline is 2 years. And the exception is, of course, unless there's a motion for a judicial review. So that may push back the deadline to when the motion is dismissed, or if it's not dismissed, then the final determination of that application. But again, the 2-year period is quite a substantial amount of time. And given that, again, the idea of adjudication has been, as has been said a number of times at the webcast, is to make sure that the parties are getting on with the job, it's going to be more likely that something's going to be resolved within that 2-year period. So you have some time before you actually need to enforce. It's kind of a thing to do after essentially many of the options have failed. Now, the notice of filing, the Act specifies that it has to be 10 days. And you have to, after 10 days after you file, you have to give notice. But there's nothing in the Act that says what happens if you don't give that notice. So I'm not sure if that's going to be an issue that comes up and if there's going to be some penalties for not doing so. Of course, everyone should try and comply with the 10-day deadline. It would just make things a lot easier. And the last point to note in this section is that if a determination comes out and requires, say, an owner to pay a contractor, the owner doesn't pay, the contractor then has to take the decision to court to try to enforce it. The payment is to any subcontractors is essentially stayed pending the resolution of that enforcement. It's kind of a back-to-back provision that ensures that the subcontractor will only get paid when the contractor gets paid with the owner, for example.
To me, it'll be interesting to see how much we see this enforcement mechanism actually used in the courts, given that contractors and subcontractors are given the right to actually suspend work on the project until they're paid. That seems to me to be a much more immediate and threatening option in terms of actually forcing payment as a result of the adjudicator's decision. So I am seeing from my colleagues here that we are at the end of our rope, Pavle.
Yeah, so we do have a few more minutes to take some questions, and the webcast doesn't have to end. We have a few more topics to just wrap up on. So unless there are any questions that are going to be coming in, I think we would just touch very briefly on 2 more things. One of those just being confidentiality of enforcement. So as Duncan and Jacob have talked about in their presentation, confidentiality is an issue. But the bottom line here is that if you're going to take a determination and have it be enforced, you're going to have to give up that confidentiality. And without getting too deep into it, the idea is that you can't have a process that doesn't allow for enforcement. It would just be contrary to the Act. So to the extent that anything is contrary to the Construction Act, it's not going to fly. And the final issues that we just wanted to talk about were, how does this work in practice? So we came up with a very quick scenario about some topics that we could just get into very, very briefly. For example, take the example where an adjudicator releases a decision that requires a contractor to pay, say, $1.5 million to a subcontractor. Now it's day 17 after the communication of the decision, and no payments have been made. And the contractor is hoping to not have to pay, obviously, and maybe get the determination set aside. So what are some of the things that one would look for if the scenario came up? So obviously the first thing is that, day 17 is past the 10-day deadline. So already you're looking at a possible issue there. The other issue is, and Michael, you can speak to this, is the contractor says, I want to get the determination set aside. What would you say?
Well, I think we'd certainly have to communicate to our contractor client that there's a lot of risk associated with taking that step to challenge on the basis of judicial review and have it set aside, because as we've talked about, there's no stay that automatically goes with that. And once you're past that 10-day mark after the decision's communicated, you have that looming risk of your subcontractor pulling up stakes and demobilizing and waiting until he or she gets paid to remobilize. And all of those costs, of course, would be on the contractor and payable, notwithstanding the application to set aside on judicial review. So my own view is that taking those steps to challenge under the Act are certainly a very high-risk proposition without necessarily a lot of upside, in the near term.
Yeah, that's right. I would agree with that. And, if it's day 17, you're still within the 30-day window. So in theory, you can challenge, but it's going to be perhaps an uphill battle. And now looking at it from the subcontractor's point of view, let's say the subcontractor is in a cash crunch and doesn't want to have this information made public. I think the risk here is that if the subcontractor says, well, I want to enforce, but I don't want to give up confidentiality, it goes back to the discussion that we had on confidentiality. Unfortunately, it's unlikely to work that way. There's going to have to be something given up there if you actually want to enforce. And the last point is just, if you have clauses in your contract that do touch on things like confidentiality, and we can see one here, it says, for example, a decision of the adjudicator shall be confidential and shall not be made public for any reason whatsoever. Just make sure those are drafted extremely carefully. I would have concerns with this one. It doesn't talk about, who is to keep the confidentiality. Is it the adjudicator or the parties? You probably want to make that clear. Another thing that gives me some concern with this clause is that it seems to be, again, to go against the Act. So the Act will prevail. And whenever you're trying to draft anything that seems like it might not comply, just make sure that you review those clauses very carefully. And I think that's it. These are just two very quick scenarios trying to apply what we've just discussed on our webcast. If there's anything else from you.
No, I think I'm being waved down. Our time is all but up. I want to thank all of our listeners out there and also all of our guest speakers today. Of course, if you have any questions related to anything we've discussed, if you send them in on the chat module, notwithstanding that we're out of time here, we'll certainly take the time to be in touch with everyone that does reach out and hopefully have some worthwhile answers for you. Thanks, everyone. Take care.